All right, all right, all right, all right. Like the camera's too close. Pull back, pull back. There we go. There we go. All right, like, subscribe. Again, Levi Apparel. Um, Levi Apparel. All right,
All right.
cool.
So what I'm going to
so,
say is, yes, the videos are
hold on
evidence.
1 second. Hold on 1 second.
You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem.
All right, so I'm rebroadcasting, I guess, the Cam Recates, and what's going on. All right, so okay, cool. So we're gonna find out possibly today, if not maybe next week, who knows, but we'll find out. So whatever happens happens, but this is the Cambry case that's going on. I'm in Massachusetts, so this is interesting for me because we've been wanting to know, like, what's the result. You know what I'm saying? Most people here are hoping that she's not guilty, and they find who actually is, because they feel that there's lack of evidence, if there is, or who knows, maybe they were able to find enough evidence to say that she was, or who knows if she wasn't. I don't know. They know, but she's gonna be tried by a juror of her peers, and then they deciding what is what. Okay. All right, cool. With that said, like, subscribe. Again, this is amazing. This is amazing. Levi Apparel. Once all this is done, I'm gonna reclip it. Right, I'm gonna do a little bit of montage, talking, all that stuff, and then make a t-shirt. Not now, but I'm gonna reclip this and then add more to it and make a shirt of whatever the verdict was. All right. Okay. Or whatever. If I do, if I don't, who knows? Okay. All right. All right. Cool. 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 All right. Hold on. Hold on, real quick. Hold on. There we go. All right. And here it is.
OUI charge 002 number 5 is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law. And then there are suggestions that we have regarding the edits that the court has made to the verdict slip. And I'm happy to go over those with you and put those on the record.
Okay, go ahead.
With regard to going from the top to the bottom, just under number one reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the consistent language that it's added throughout the verdict slip. If you, quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period. That's the only place that that language doesn't appear, and I think it should appear.
Okay.
The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical check one or both of the following, I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right, I think I'm going to leave it because it appears only under the guilty.
It appears only on.
Under the guilty. So go ahead. I'll hear you further.
Going further, going under number 3, toward the bottom of the page, in the parenthetical that the court suggested, which we find is excellent, if you find the defendant guilty of the lesser offense of involuntary manslaughter, we would simply add that clause.
So we'd have to add it in all of them.
Correct.
Which makes sense. I think
Correct.
we had it in the first one.
Right.
Okay.
And then moving to page 2, at the top of the page under sub 4, again.
Hold on one second.
Of course.
Okay.
We have the same suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following. And there's a typo. It says the parenthetical
We fixed it.
Check one of. Okay.
Yes. So we changed of to or.
So my only suggestion to that would be to again add the if guilty, comma, check one or both of the following.
Okay.
On that page, going down to the bolded parenthetical, same thing. If you find the defendant guilty of the lesser offense of motor vehicle homicide.
Okay.
Moving down under sub 5, the
We still
OUI.
need to say stop and sign the verdict.
Did I pause it? Yeah, I paused it. Hold on.
And those are the edits that we have suggested for the verdict slip.
Right. Mr. Brennan?
I don't have any disagreement with the edits.
Okay.
The idea of instructing them on the nuance of selecting one guilty or not guilty, I don't think needs to be explained. I think with the edits, this proposed instruction explains it.
All right. Would I?
I don't have any issue with if you state, if you decide on a lesser included offense, it does not include the earlier offense. And I'm not sure of the exact language I can use. I don't think that's necessary, but that is something I wouldn't have an objection to. But I think the form as you filled it out with the edits is going to be sufficient for them to follow.
What do you think about the defendant's position that if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it, it means you have found her not guilty of each of the others.
That would be fine with us.
I think it's better if you find her guilty of any lesser included offense. It would not include the higher offense.
All right.
I think that's just confusing.
So what I planned on doing was bringing them out and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain if you find the defendant guilty, you're done. Stop, sign the verdict slip, and let the court officer know you have a verdict or something. I think I'll walk them through it like we do in civil cases.
I don't have any objection to that. The only other thing is the digital instruction.
Yes.
We don't believe that it's necessary. I don't think that we should reemphasize that, and we're not asking for it.
All right, so you're waiving it?
We're waiving it.
Okay.
Yes,
All
thank
right,
you.
I will do humane instruction, humane practice instruction. So I need 5 minutes, and Tori, your computer, to amend this if we can, and we'll make copies. So we'll bring the jurors in. Let them know that we'll be bringing them in shortly, Tony. All right, thank you.
They back to the fan. All right, guys. So, um, like I said, this is the Karen Reed murder trial. MA versus Karen Reed, right? MA, Massachusetts. The Massachusetts woman accused of drunkenly murdering her boyfriend, Boston cop John O'Keefe, by hitting him with her car is set to appear in court on Monday. Um, okay, cool. All right. Well, it's past Monday, and we're looking for the results, pretty much. Um, and hopefully, hopefully things get set. Hopefully things get set, and uh, we're able to get a verdict. Who knows? Who knows? All I know is like this gotta be a lot of money for this lady, like a lot of money, you know. But hey, you know what? For them doing a trial on this and making sure everything gets to light, even having to retrial it, I think Massachusetts deserves an applause. Hopefully, the we call it justice is served, and she's able to successfully um, get a result. You know what I'm saying? So yeah, at the end of the day, at the end of the day, uh, most importantly, I think again, people are not looking at the mother and the father that's going through all this, and also his family. You know, that's going through all this. They just want to know answers. You know what I'm saying? They just want to know answers. But yeah, it is what it is. It is what it is. All right. So, as they're getting themselves set, I don't know when they're coming back. I'm gonna leave it on, and I'll be right back. I gotta go do some stuff in the background. So this is literally my day. I've been prepping and waiting for this, like try cases, situations that's going on, news, hot weather, cold weather, whatever. So I'm gonna try my best to try to broadcast more. I want this year to be a little bit more of a nuance as far as like what I'm bringing to you guys. But as usual, in the background, I'm gonna be showing you I'm making content for T-shirts and all that. Right now, I'm doing the other half of the totes. Had to wait for the ink to come in. The ink is here, the Rhinenet ink, and now we're just once this is done or while it's going on, I might just be screen printing. But I gotta go and come back. I'll be back. Give me a second. I have to do something. Um, okay, let me go to my other login. Bam. I'm just going on to my YouTube channel to put some descriptions. I forgot to, but it is what it is. Ooh, the anti-damage channel is on right now. Yeah, I might have to go check that soon. Mhm. Okay. Okay, control V. All right, link is there. Okay, and save. Awesome, awesome. Now the link is there, so you gotta put a link to support. Um, sorry, to support the different channels and all that stuff. Also check out my link for my YouTube, Facebook group. There's a lot of people there having fun, posting stuff, all that. Um, Other than that, oh, in case you guys are wondering, what happened to the Epson 1400? It's right here. It's right here. So I have it right underneath, right there. I just need to finish setting it up. I have this I need to set up to connect to that right there. Other than that, I'm good to go. Yeah, so it's here, Epson 1400, and I have the Epson 15,000. So two DTF printers. Yep. So two DTF printers. That's gonna get me to the point where I can actually, you know, do good, do good. So all right. So let's go back to the trial thing and see what's happening. Mhm. Oh, man. All right. So let us unmute this. Where are you? Dang it. When you have multiple screens, hard to find the mouse. Where is the mouse? Oh, there it is. All right. Okay. This is the part you didn't see her supporters. This is what's going on outside of the courthouse as they're doing everything they're doing. So everybody that's in pink, I believe, are supporters of her or whatever. Then you have law enforcement, you have everybody outside, and this is what you just saw earlier.
All right, so I will
With the
hear
trial
you
going on.
on
So yeah.
the first question, the time of the OUI. Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from whoever's, you're standing up, so I'll hear from you first.
Okay. On question number 1, what is the time frame for the OUI charge, offense 002, section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be
All right, let's
something
get it
along
back
the
to where
lines
it's
of,
supposed to
ladies and
be.
gentlemen of the jury, you have the evidence. It's your
You
decision.
are the fact finder.
You're the fact finder.
Mr. Brennan, or whomever from the Commonwealth,
My suggestion would be 12:45.
and why is that?
The case has always been focused at that time. I don't think there's anything specific in the indictment regarding the time.
Do we have the indictments?
No.
If it's not in the indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
Understood.
All right.
I agree with the court on principle. I just don't have the indictment memorized, so I don't remember. If we can pull that up.
There's the star right
I don't
there.
think there's any
There
time.
she is.
All right, so I'll say you have the evidence, and remember, you are the fact finders, or something to that effect. All right. Are the video clips of Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them, and then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you.
This is
Otherwise,
definitely
it's
going to be
fine.
a movie. Or one of those like documentaries, because this case it's deep.
Okay. What's the Commonwealth's position?
We have a different perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been introduced substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case to say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes. You should weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence. It suggests that there's some deterioration or further analysis that is different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence, and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to curtail it or to limit it in any fashion.
My only suggestion, Your Honor, is that every single piece of evidence that's provided to them. It's in keeping with Massachusetts laws, in keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a misapplication of the law. I think the Commonwealth's suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight. So I think the appropriate comment by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
Right, let's pen this right now. There we go. There we go. Bam. All right, all right. Let's see if anything, any new developments. All right. Well, while they're doing their thing, I got a lot of things I gotta do today. My DTF printer, like, for some reason, it's not printing. DTF meaning direct to film printer. It's not. It's not turning on. I changed the printhead. I changed the ink chip recognizer, and everything was great. It was on, and then eventually the whole thing just turned off because of a power surge that it ended up having. So hopefully this thing gets back in order.
So what I'm going to say is, yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, then I'll go and I'll read the electronic communications and the humane practice. That covers it.
I don't have a principled objection to it if the court adds the word "if any."
I understand.
Because I don't want them to think, for instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is, very simply, you give this the weight, if any, that you decide is appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary, and it tends to suggest they have to give it weight.
Okay. So your objection's noted. Now let's get to the third one. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
Your Honor, I appreciate the effort that the court went to amend the verdict slip as it relates to count 2, and I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3 is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? The answer is no, obviously. And perhaps we could formulate an answer that says something along the lines of no, new verdict slips have been provided that will make it more clear, or something of that nature, as well as a decision of guilty on the OUI charge 002 number 5 is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law. And then there are suggestions that we have regarding the edits that the court has made to the verdict slip. And I'm happy to go over those with you and put those on the record.
Okay, go ahead.
With regard to going from the top to the bottom, just under number 1 reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the consistent language that it's added throughout the verdict slip. If you, quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period. That's the only place that that language doesn't appear, and I think it should appear.
Okay.
The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical check one or both of the following, I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right, I think I'm going to leave it because it appears only under the guilty.
It appears only on...
Under the guilty. So go ahead. I'll hear you further.
Going further, going under number 3, toward the bottom of the page, in the parenthetical that the court suggested, which we find is excellent, if you find the defendant guilty of the lesser offense of involuntary manslaughter, we simply add that clause.
So we'd have to add it in all of them.
Correct.
Which makes sense. I think we had it in the first one.
Right.
Okay.
Okay, come on. There's a lot of chatter. Come on. Woo. Let's go, let's go. Let's go. Let's go. This is about to happen. This is about to happen. I'll be back.
All rise to the court, please. Jury taken. Court's back in session. You may be seated.
All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes